Good morning, participants. On 1st of December, I had a chance to interact with you on Krishna Water Dispute Tribunal. That was the first tribunal established in 1969. And that tribunal, while giving its has permitted the review of its decision anytime after 31st May 2000. The separate details of that KWDT1 were already given. However, those who have joined in today's meeting for the first time or might have missed earlier lecture, some history of KWD chairperson '73. Further report decision
Sorry.
Sorry for interruption. So the tribunal has delivered its report, come decision, in December 1973 under section 5.2, and further report was given under section 5.3 in May 1976. The final report of the tribunal has been published in the Gazette of Government of India on 31st May 1976, and from that date onwards the decision became binding on all the party states. This decision is continuing to be effective since then. The total basin area of Krishna Basin is 2.59 lakh square kilometers, out of which 26.81% lies in Maharashtra, 74% lies in Karnataka, that time it was Mysore state, and 29.40% lies in Andhra Pradesh. This is the basin map. As already told you in the last lecture, in 1961, Krishna was established by Government of India, and Commission has divided the entire Krishna basin into 12 sub-basins. That is Upper Krishna, Middle Krishna, Lower Krishna, Upper Bhima, Lower Bhima, Ghataprava, Malaprava, Bhadra, Vedavati, Musi, Paleru and Muneru. The same basins were adopted by KWDT1 and by KWDT2 also. KWDT1 decided the water with the help of three-party state as 2060 on 75% dependability. The tribunal has also accepted that after 1968-69, whatever water utilization is done by three states, indeed, regeneration of flows, also known as return flows, and these were estimated to be 70 TMC. So tribunal has made allocation within the three states as Maharashtra 560 TMC plus 25 TMC return flows, that is 585 TMC. Karnataka 100 TMC plus 34 TMC return flow, 34 TMC. And Andhra Pradesh 800 TMC plus 11 TMC return flows, that is 811 TMC. Thus, together, the flows of air, flows distributed 2130 TMC. While giving the decision, the KWDT1 has considered that the projects which are utilizing more than 3 TMC shall be treated as major projects. Those utilizing between 1 to 3 TMC as medium projects and less than 1 TMC, they are classified as minor projects. For the effective use of water, the tribunal has considered that depletion of river flow should be the use. Flows from major, medium projects should be measured, and purpose, whatever diversion has taken place would be considered 100% use. For minor irrigation projects, however, the area which has been irrigated is, and with the help of three states due by the tribunal, these duties, the utilization of the water for the minor irrigation projects has to be decided. As far as domestic water use, industrial water use is concerned, the tribunal has 20% will be treated as a domestic use. Whatever water has been utilized, out of that 20% will be considered as a domestic use and 5% to be considered as the industrial use. While allocating the water, tribunal has protect the existing projects undertaken. And for all the three states, and it was observed that hardly 300 and odd TMC is available for distribution by this honorable tribunal. So these tribunal, out of the projects presented by the various states, have considered the projects as worth consideration and not worth consideration, and allocated the water to the states as 120 TMC, 180 TMC and 50 TMC approximately to Maharashtra, Karnataka and Andhra Pradesh, and total utilization permitted was 500, 800 plus 25, 30 and 11 TMC as regional force. But a distinction has been made by this tribunal that this allocation which has been permitted is in block and it is not allocation. The tribunal, already I told you that they permitted the review of their decision after 31st May 2000, and it was meant that the utilizations which have been undertaken should be protected while the decision. The essence of allocation was that there was no sharing of deficits, and whatever water the states get, they have to utilize it. Karnataka may have pleaded percent dependent, but should permit since you not is water available, water use has however, at that age, yes, however, at this,
एक बार विदाउट हेडफोन देखिए.
From the fuller utilization consideration and surplus and deficit sharing by the states can be at 25% by Maharashtra, 50% by Karnataka, and 25% by Andhra Pradesh. However, there was no agreement within the party states, and as already informed to you that Krishna Tribunal was all the while persuading the states to an agreement, and most of their decisions have been declared after the agreement was signed and placed before the tribunal in all the matters, that is protection of the existing uses, availability at 75% dependability, etc. So since there was no agreement, and another issue was for fuller implementation there has to be an authority. Though tribunal could have done it, but as there was no agreement between the party states, tribunal left it to the wisdom of the party states for appointment of authority, and hence scheme B was not the decision by KWDT 1. Only scheme 1 was ordered, and that has come in the final order which has been notified by Government of India. While KWDT 1 decision has come in force in 1976 and its decision was out, there was some rethinking at the Government of India level, and in 1980 an amendment was made by introduction of clause 6A under section section 6 of the Interstate Water Dispute Act 1956. And that's introduction of the act ended without prejudice to the provisions of section 6, the central government may, by notification in the official gazette, frame a scheme or schemes whereby provision may be made for all matters necessary to give effect to the decision of a tribunal. So this is a major amendment to the Act in 1980. Amendment, and just before 2000, in 1997, State of Karnataka filed a suit known as Original Suit number 1 of 1997 against Andhra Pradesh and others. Similarly, Andhra Pradesh has also filed a suit, that is original suit number 2 of 1997, against Karnataka and others. The suit intended revoking of original jurisdiction under Article 131 of the Constitution. The Karnataka case was that the scheme be formed part of the decision of the tribunal and therefore required to be notified by central government under section 6 of the Act. A prayer for injunction restricting Andhra Pradesh to execute certain projects, that is Telugu Ganga, Shri right bank canal, Shri left bank canal, Bhima lift irrigation scheme, Puli Chintala projects, etc. The Karnataka has also raised questions relating to scope of extent of 5C. The final order relates to limits of utilization of water by 3 respective states as per their share by the tribunal. That is the share in 75% of the water plus return flows. Andhra objection relating to maintainability of Article 131 of the Constitution, being Section 11 of the Act 1956, in view of mandate under Articles 262 of the Constitution. Scheme A is the decision of the tribunal, which came into operation from date of publication, and Scheme B, not being the part of decision, is unenforceable. As per clause 5C, Andhra Pradesh was entitled to use remaining water flowing into the river. My last lecture, you can recall that Andhra Pradesh has been permitted surplus water, but right was not given. But here they were claiming that they are entitled to use. Further argument was Scheme A had come into operation and review also have been provided after 31/5/2000. Implementation of Scheme B at this stage would be inequitable and wholly uncalled for. Maharashtra took same stand implementation of Shri as taken by Andhra Pradesh. However, Maharashtra was in agreement with Karnataka regarding remaining water of Krishna and restraining the projects of Andhra Pradesh. The central government has also stated that Section 11 of the Interstate Water Dispute Act is not maintainable. Supreme Court observed that looking to the dispute, it would be appropriate in case any party approach central government for constitution of tribunal to solve the dispute. Parties can place the data and material on the basis of which Bachawat Tribunal have evolved the two schemes, as well as place fresh data before the tribunal. The Supreme Court were that since Scheme B is not the decision. Supreme Court has no jurisdiction to intervene in the matter. Accordingly, suit number 1 of the state of Karnataka was dismissed. Regarding suit number 2, the tribunal has observed that Andhra Pradesh has made prayed for several reliefs, but the main reliefs were related to the Almaty Dam. The raising of the height proposed by Karnataka to 524.256 meter was one issue from Andhra Pradesh side, and the submergence of its territory due to Almaty. The Supreme Court observed that such questions may be gone into by the tribunal. The tribunal will also be entitled to consider the question of reallocation of water if new data is produced before it on the basis of improved method of gauging. And accordingly, suit 2 of the Andhra Pradesh was also dismissed. After the dismissal of both the suits by the Supreme Court, the party states have their letter of complaints. Karnataka was the first to submit its letter of complaint on 25th September 2002, followed by Maharashtra on 27th November 2002, and State of Andhra Pradesh on 23rd January 2003, requesting the central government for reconstitution, for a constitution of another dispute tribunal. The central government constituted the tribunal by its letter dated April 2, 2004. Meanwhile, from the Supreme Court's judgment to the constitution of tribunal, the central government has amended the act once again. In it has introduced section 6A. In 2002, the central government has introduced amendment to section 4 of the ISWDT, in which they made a proviso under section 4 and introduced that, provided that any dispute settled by a tribunal before the commencement of Interstate Water Disputes Amendment Act 2002. This is a very important proviso made in the Act in 2002. In addition to Section 4, Section 5 was also amended, in which a period, specific period, has been indicated by the central government that tribunal shall investigate the matters referred to it and forward to the central government a report setting out the facts as found by it and giving its decision on the matters referred to it within a period of 3 years. Further, they have provided that if the decision cannot be given for reasons within a period of 3 years, the central government may extend the period for a further period of not exceeding 2 years. The tribunal under section 5(2) has to be submitted within 3 years, and due to some exigencies, it can be submitted within 5 years. But after 5 years, there is no further extension. This is a very important provision made under section 5 by the 2002 Amendment Act. Further, the central government has also amended under section 5 by introducing subclause 3. In report is to be submitted 5(3) in 1 year, but and extension if it could not be done. In section C, further they have introduced one more amendment stating that decision of the tribunal after its publication in official gazette by the central government under section 1 shall have the same force as an order or decree of the Supreme Court. Further, there are amendments to but the most significant is that there was a proviso to section 4, and that is the question debatable before KWDT 2 is what is the matter that is considered as a settled matter and what are the matters not settled. After the three-party states have submitted their statement of case, their letter of complaint, replies, rejoinders, and voluminous documents, the tribunal has framed issues with the help of counsels of the party state and having gone through the pleadings submitted by the party. What pleadings which were the part of the complaints of the party states are Karnataka stated implement scheme B framed by Bachao Tribunal. Second issue was regarding summer flows in Bhima River to be maintained, and they alleged that Maharashtra has created excessive storages in its area. These were the three main complaints of the state of Karnataka. The state of Maharashtra stated that the of surplus flows should be done by this tribunal. Maharashtra has objected to Almaty stage storage in Maharashtra. Objection to project Uttar Pradesh using surplus water, and Maharashtra demanded certain in westward diversion in Bhima and Ghataprabha basin. The Andhra Pradesh complaint suggested that water has been actually used by upper states. It should be restricted to that allocation, and the balance water or the unused water by the upper states should be redistributed. Now, they have also demanded for restrictions on storages and uses by upper states. Time supply of water to projects in Andhra Pradesh. And they also suggested that diversion of Maharashtra should be stopped. Having and pleadings, statement of cases, the tribunal has with the help of party states, their councils, following 30 issues. The issue number 1 is whether appointment made by the previous Krishna Water Dispute Tribunal 1 by its notified gazetted decision dated 31st May 1976 based on 75% dependable yield of 2060 TMC is liable to review or reconsideration. So clearly, the issue number 1 is outcome of Proviso 4 added by the Parliament. Issue number 2 is what is the available flow of water in the river Krishna and its valley, and at what dependability and on what basis it is to be quantified and distributed, and whether any surplus flows are available for equitable apportionment among the riparian states. If so, on what basis water can be distributed among the riparian states. Issue number 4, whether any surplus water flows are available after equitable distribution of the water among the riparian states, which may be utilized by the state of Andhra Pradesh alone as claimed by the Andhra Pradesh. Issue number 5 is whether the complete scheme B as drawn up in the further report of KWDT 1, including the shares of states, be adopted as a decision in the present adjudication. Issue number 6, whether the equitable apportionment of surplus water include claims for diversion of waters for use outside the Krishna basin. Whether 7, whether storage in Almaty Dam should be regulated to have timely releases to safeguard the loss of Kharif crops, if any, in the state of Andhra Pradesh without affecting the success rates of Almaty and Narayanpur dams. Whether augmentation of water in river Krishna by diversion from any river would enter the contesting states to claim greater share in augmented water. Issue number 9, whether the state of Maharashtra should be permitted to transfer any portion of Krishna water to Godavari basin. Issue number 10, whether it is lawful for the state of Karnataka to construct dams, barrages or weirs which may or likely to submerge the territories of Maharashtra without its consent. Issue number 11, construction of Almaty Dam, Hipparki Barrage, Bhima Barrage has caused or is likely to cause submergence of the territory of the Maharashtra. If so, what orders or direction should be made therefore? Issue number 12, whether the state of Andhra Pradesh is entitled to use the surplus waters of river Krishna by way of permanent construction of large-scale projects and reservoirs. Whether contentions against the storages in Almaty Dam up to 519.6 meter are barred by constructive res juridicata or res juridicata. Issue number 14, whether Karnataka is entitled to storage of water up to level of 5.256 meter in the Almaty Dam, or the height of the Almaty Dam be restricted at 515 meter as claimed by Andhra Pradesh or 512 meter as claimed by Maharashtra. Whether state of Karnataka had violated the conditions required for raising the height of Almaty Dam, if so, to what effect? Issue number 16, whether the direction should be issued to the state of Karnataka forcing the flood control measures. Issue number 17, whether sub-basin wise and project wise restriction should be placed on the storages and utilizations as pleaded by the respective parties. Issue whether the storages of projects of upper riparian states be determined to meet their allocations. Issue number 19, whether the state can construct over the year storages or carry over storages. Issue number 20, whether the water disputes raised in Andhra Pradesh in subparas 9, 10, 11 and 12 of para complaint are barred from res judicata or constructive res judicata, issue estoppel and or under any provisions of law. Issue number 21 is any machinery or scheme be set to and regulate allocation of water to the states concerned or otherwise to implement the decision. Issue number 21A, whether the Tungabhadra board be vested with the administrative control and regulation over the Tungabhadra dam and its reservoir, including head regulators of all the canal systems, both on the left and right, and all its gates. Issue number 2, whether Tungabhadra board be vested with the control of the and administrative control over the Rajoli-Bandha diversion scheme, including its headworks and the common portion of its canal and the mini hydel project within the state of Karnataka, and issue necessary directions, recommendations to Union of India. Issue number 22A, whether the state of Karnataka is entitled to construct mini hydel project from the common pondage of the diversion scheme without the consent of the state of Andhra Pradesh. Issue number 23, whether the restrictions imposed on the state of Maharashtra by the Vachavat Tribunal by clause 9A and by clause 10 be removed as pleaded. Issue number 24, whether the state of Andhra Pradesh permitted to construct new parallel high-level canal at higher contour from the foreshore of Tungabhadra reservoir to enable it to fully utilize its allocated share of water in Tungabhadra project. Issue number 25, which of the projects or works of the riparian state need to be protected or permitted based on their utilization as per clause 14A of the final order or otherwise, and whether the unutilized allocated water of the riparian states be equitably distributed among the riparian states by following the principles of equitable distribution. Issue number 26, whether there should be regulated release of 5 TMC each by the upper riparian states to enable the state of Andhra Pradesh to supply drinking water to Chennai city. Issue number 27, the state of Karnataka has already exceeded its allocation in K8 sub-basin, that is the Tungabhadra sub-basin. If so, whether the state of Karnataka is entitled to construct Upper Tunga, Singatlur, Basapur, Sasalwat, storage 1 and 2, Guddat, Mallapur lift irrigation scheme, Varda, Benur balancing reservoir, Upper Bhadra project, Lakya dam and lift irrigation schemes from foreshore of Tungabhadra reservoir. Issue number 28, whether there should be time to enable the release of Andhra Pradesh to realize its allocations or designed success rate of its projects without affecting success rate of the project allocation of the upper riparian states. Issue number 29, whether the state of Andhra Pradesh is misusing the agreement Andhra Pradesh, Maharashtra and Karnataka dated October 28, 1977 by expanding the open linked channel from Shri to Pennar from 1500 cusecs to 11,150 cusecs, and by locating the offtake point in such a manner as to use the channel for irrigation contrary to the said agreement. If so, what is effect? Issue number 30, whether any scheme may be framed for conservation of water over and above the allocated shares of the states by constructing reservoirs wherever possible, which may be regulated by a regulatory authority for the benefit of three riparian states wherever there may be any shortfall. In nutshell, issues were framed honorable tribunal with the help of the party states. There were lot of exchange of thoughts, filed affidavits, cross-examinations of the witnesses, and extensive arguments and counter-arguments by councils of all the three party states before the KWDT 2. Having heard and having the pleadings, arguments, the tribunal has finally given its directives on issue 1, number 1. The tribunal has ruled that apportionment of 2060 TMC by KWDT 1 at 75% dependability cannot be reconsidered or reviewed. So this is the decision which is outcome of proviso to section 4 of the 1956 Interstate Water Dispute Act. So it was decided that 75% dependable water allocated by the tribunal cannot be reconsidered or reviewed. Now, the question of the tribunal is, then what is to be done now? In this context, issue number 2 to 4, which I have clubbed, have been deliberated by the three party states. The bit Andhra Pradesh has advocated that from his affidavit that the utilization should be restricted 18 TMC from sustainable utilization point of view, which is a lowest value even considering the 75% dependable flows apportioned by 81. Maharashtra's witness has submitted before the tribunal that taking into consideration 113 years series, that is the series up to 1971-72 as per KWDT 1 and beyond 72, this honorable tribunal has directed the party states to submit the information about the qualifications 172 onwards every year, and they had prescribed some 9 different formats: minor, lift irrigation, hydro diversion, and all. So these added utilization figures which are available, plus the discharge data, maintained Central Water Commission. Because in the last also decision was taken that whatever discharge data is available at Vijayawada plus upstream utilization will give the fair idea of utilizable flows. Similar exercise has been done here. And taking that exercise into account, the 3 states have submitted their views through their witnesses on the availability of the flows. The Andhra Pradesh witness has submitted that consider the 112-year series from 1894-95 to 2005-2006, that is 112-year series. This 1890 TMC should be considered as from sustainable point of view as utilizable flow. As already told by me some time back, that this flow was even less than 75% dependable flow already distributed by the first tribunal. The Maharashtra witness has considered 113 years series, that is from 1994-95 to 2006-7, because utilization figures and gauge data was available. In doing so, Maharashtra's witness has also introduced a concept of weather cycle. And normally, weather cycle we consider 30 years weather cycle or 40 years weather cycle. So he has distributed that 113 year series in weather cycles of 30 years, 35 years, 40 years, computed the 75% average, 50% dependable figures from each series, and there made a representation that the average flow available from different series varies between 183 TMC to 21 TMC, and therefore, according to him, 2600 TMC is a safe assumption for permitting utilization of the average flows. Through his affidavit, he has also pointed out that the utilizations which have been taken by all the 3 party states has already reached a figure of 2196 TMC, which is more than the 2130 TMC allocated by the first tribunal, that is KWDT 1. And within the utilizations, Maharashtra and Karnataka's utilizations are not to the extent permitted by KWDT 1, which state of Andhra Pradesh was claiming that whatever has not been utilized beyond 2000 should be redistributed. So he has stated that considering these balanced utilizations, the capacity which will be utilized in coming years would reach a figure of 2,344 TMC. But was remembering that last time Mr. Chetan Pandit had raised this issue, who has demanded 65% dependable flows. So no state has demanded 65%. They have demanded that average or 50% dependable flows should be redistributed. Maharashtra was asking for average flows because KWDT 1 has also admitted that average is the uppermost limit to which water can be extended, water can be utilized with the construction of chain of carryovers. Therefore, he is of the opinion that 2600 TMC should be now allocated. The state of Karnataka has selected a series of 50 years from 1948-49 to 1997-98. And considering this 50-year series, they have advocated that the flows up to 2647 TMC can be apportioned by this honorable tribunal. This honorable tribunal, having gone through the affidavits, their cross-examinations and all that thing, has not relied on the evidence of all the states, but observed that it is prepared by participating states. Even at the time of KWTT 1, they had observed that there is a breach in Vijayawada Anicut, which was rectified and new Prakasham barrage was constructed in 1961-62. Therefore, this tribunal has considered that unblemished data of discharge is available from 1961-62 onwards, and they, with the help of their assessors, has analyzed a series of 1961-62 to 2007-2008, that is the 47 years series, and calculated the yield as 2,578 TMC on average basis, 20 to 90 TMC at 65% dependability, and 23 at 75% dependability. This honorable tribunal has also observed that, considering the utilizations in 2007-8, the utilization has reached a figure of 2,306 TMC, which is very near to the figure of 2293 at 65% dependability, and therefore this tribunal has allocated water in second instance of dependability. So thus answered in this manner. The tribunal found that this 47-year series indicates 75% dependable flow as 2173, but due to the proviso 4 that the settled matter cannot be reopened, tribunal has ruled that in issue number 1, answer to issue number 1, that this 75% dependable flows cannot be reconsidered or reviewed. Issue number 5, this found that the implementation of scheme B would not be possible. Issue number is the diversion of surplus flows for use outside the basin is permissible and legal. On issue number 7, they found that regulated releases from Almaty Dam to the extent of 8 to 10 TMC during June and July should be permitted. Out of the 30 issues, issue number 8, 14, 19 and 20 have been answered in affirmative. Next. Whereas issues number 9, 16, 22, 24, 25 and 28 have been answered in negative. Regarding the territory of Maharashtra, observed that there is no submergence in the state of Maharashtra by Almaty and Hippargi barrage. A lot of arguments were done by the party states regarding Almaty and Hippargi. It is interesting for the information of the participants that at the border between Maharashtra and Karnataka, river bed level is 518. So for a layman, when the level of the Almaty is permitted to 524 or even for that matter 519.6, there will be water above 518 in the river, and that causes the submergence in the territory of Maharashtra. With 524.256, the submergence is larger. If you look at the Hippargi FRL is 524.87, I think, or 81. So that will also cause the submergence. Therefore, Maharashtra was all the while pleading that there will be submergence of its territory, and this is with the siltation taking place over the years, and there were heated arguments regarding the siltation rate. Therefore, this honorable tribunal directed the party states to appoint an independent agency, and what is the siltation rate actually experienced till about 2009, since the construction of Almaty reservoir should be worked out by this agency. And the agency has submitted a report. Considering that report and backwater calculations, the tribunal rejected Maharashtra's case and considered that Almaty, or for that matter Hippargi, will not cause any submergence. It is to be noted that Almaty reservoir is being constructed or has been constructed at a distance of about 202 kilometers from the border between state of Maharashtra and state of Karnataka. And Hippargi Dam, Hippargi barrage, gated barrage, has been constructed at a distance of about 77 kilometers. Though during the full reservoir there will be submergence, but that submergence is limited within the river banks, and therefore Maharashtra's proposal was rejected. And issue number 10 as well as issue number 11 has been according to that there will not be any submergence in the state of Maharashtra. Issue number 12, that no such restriction now requires for utilizing part of surplus flows allocated. Issue number 13, FRL of Almaty can be raised to 524.256 meter. Issue number 15 is there is a need of UKP, that is Upper Krishna project, stage 3, and that required water and storage is available at Almaty. It has been held that no submergence was likely to be in the state of Maharashtra on the basis of report of hydrographic survey carried out by an independent. Issue number 17, there will be deviations in the capping and restrictions which we propose to deal with at distribution of water. Issue number 8, in view of the fact that Andhra Pradesh realizing its allocation of 800 TMC, the issue stands deposed. Issue number 21, Tungabhadra Board shall be abolished after constitution of implementation board. Issue number 23, the issue stands disposed of by considering the distribution of available water. Issue number 26 and 29, each state would contribute 0.30 TMC in equal quantity distributed in the months of July, August, September and October, and 1.70 TMC distributed in 4 equal installments in January, February, March and April for Chennai water supply. Issue, the tribunal observed that there is sufficient water available for taking up 3 additional projects by Karnataka in the Tungabhadra sub-basin. And issue 30 is that none of the states could indicate any site in the basin for storage, hence no one consider this issue. So these are the rulings on issue findings by the tribunal. Already I had dealt with the issue of finding of the availability of water by the tribunal. As already pointed out by me, the tribunal has noted in 2006-7. I think I had said 2007-8. It's not correct. It is 2006-7. Actual utilization by 3 states has reached a figure of 2,313.06 TMC, which is close to the figure of 2293 assessed by the Honorable Tribunal at 65% dependability, and therefore Tribunal permitted the yield at 65% dependability. So, availability of water issue has KWDT has permitted 26 TMC at 75% dependability as yield of the Krishna River. After considering the additional utilizations undertaken, this tribunal analyzed 47 series from 6162 to 2007-2008 and worked out average flow of 2578 TMC, 50% dependable flow of 2626 TMC, 60% dependable flow of 2528 TMC, 65% dependable flow of 2293 TMC, and 75% dependable flow of 2070. This tribunal also utilization in which Maharashtra utilizes 0.65 TMC, Karnataka 695.97 TMC, and Andhra Pradesh 1065.44 TMC. There was issue from Andhra Pradesh side that the upper states have created large reservoirs, large storages than their requirement. Andhra Pradesh was claiming that the storage created by upper stage are not required for the utilization which has been permitted. So the factual position has been recorded by this honorable tribunal, and this tribunal has also observed that there are sufficient storages created already in the system, and therefore higher allocation can be considered. They have observed that the gross storage capacity of the three states is 1919 TMC, and the live storage capacity is 1368.43 TMC. In addition, minor irrigation storages by all the three states is 381 TMC. So therefore, the total storages available can handle 2296 TMC, which is nearest to the figure of 2293 TMC at 65% dependability, and therefore they fixed the dependability factor as 65%. That tribunal, having worked out the available flows and this thing, what are their considerations before this honorable tribunal for distribution and apportionment of the available water? The tribunal has observed that the availability of water is limited, but demands of the riparian states are unlimited. Participants must be recalling that in KWDT 1, the total demands of the three states was exceeding 4,100 TMC. Before this honorable tribunal, the party states have demanded their requirements, which were totally exceeding more than 4,800 TMC. Next slide will give you those details. So tribunal has observed that considering the demands of the states, the water availability in the Krishna River, even at average or 50% dependability, is much less than the demands of the three states put together. So this is one important observation of this honorable tribunal. The distribution, they noted, the distribution of water of interstate riparian river becomes more difficult and complicated. Needs of the people of different sub-basins of the river valley, they are different. The drought-prone area in different states falling in the basin is different. In circumstances, a state may have to divert water to use outside the basin because of their drought-prone areas. There are variety of reasons as a result of which no uniform formula can be applied. Distribution of water of a river is to apply principle of equitable distribution amongst the riparian states. This is the same view considered by KWDT 1 also. And they have said that equitable distribution does not mean that equal distribution. The priority in the use of water may differ between one basin and another basin, and also between one part of the basin and another part of the basin. Some efforts seem to have been made to prioritize the items as follows: domestic use, navigational use, flood control use, hydroelectric use, agriculture and irrigation use, competing priority between irrigation versus drinking, rural versus urban, irrigation versus power, flood moderation, cost of construction of uses versus maintenance of minimum flow, irrigation versus fish culture, wet crop versus aquaculture, rice cultivation versus irrigated dry, irrigation versus hydropower, peak demand of hydropower generation versus peak demand of irrigation, tourism versus hydropower. So these are the different aspects this tribunal has considered. And then they said the question of relative priorities and competing interests, as indicated above, had taking into consideration the principles of reasonableness and equity, and also taking into account peculiarities of basin-wise scenario. It is submitted that for the purposes of equitable apportionment, relevant factors would be basin population, irrigation facilities, need of drinking water and livestock, and so on and so forth. So far as factors wise drainage contribution by each state, the population within the basin, the extent of irrigated and unirrigated area, and drought prone area and scarcity areas, etc. are concerned.
Slide 3.
These factors may not individually be decisive, but certainly have a relevance collectively to assess the overall situation about the needs of the area and the extent to which such needs can be catered. Background of the facts and figures as indicated, the needs of the states in the Krishna basin may be considered. These facts relate to population of 3 states in basin area, their number of drainage contribution, drought prone area, the area in each state, etc., and the allocations already made. One single factor does not count much in allocating the water of an interstate river, but all the factors indicated earlier taken together have a cumulative effect in assessing the needs and scope of allocation for the projects of a particular state, as against the requirement how much water is available for distribution. The availability of average flows, which comes to 2578 TMC, and availability at 65% dependability, which comes to 2293 TMC, and KWDT1 has already allocated 2130 TMC. Therefore, the dependable flows available for distribution presently at 65% dependability are to the extent of 163 TMC only. Beyond 65% dependable flows, they have quantified that the surplus flows available for distribution are 285 TMC. That is 2578 minus 65% dependable flows. Next. I had already indicated that it is close to about 4800 TMC. The demands of the 3 party states: Maharashtra demanded 1168 TMC, Karnataka 1400 TMC, and Andhra Pradesh 2224.72 TMC. It would be interesting to note that Andhra Pradesh witness has said that only 1890 is a sustainable flow. Under the background, on the background that their demand is 2200 and odd. Scarcity areas, they are 50,242 square kilometers in Maharashtra, 52,000 kilometers in Karnataka, and 45,493 square kilometers, which is comprising of DPAP and DDP in Andhra Pradesh. So of the 2.59 lakh hectares, 2.59 lakh square kilometers, 1,41,000 is the scarcity in the entire Krishna basin. The population-wise, 1991 census indicated population of Maharashtra as 185.14 lakhs, Karnataka 219.6 lakhs, Andhra Pradesh 193.24 lakhs. The 2001 census indicated these populations to be 225.18 in Maharashtra, 258.82 in Karnataka, and 229.54 in Andhra Pradesh. Considering the average growth in 2006, the population figures would be 309.91 Maharashtra, Karnataka 327.78, and Andhra Pradesh 3.34 lakhs. The irrigation scenario of the three states has also been considered, and you will see that Maharashtra has the least irrigation of 18% about, Karnataka 26%, Andhra Pradesh has 44% irrigation, and that time India's average was 40. All states together was 40%. So Maharashtra and Karnataka had much less irrigation as compared to national average as well as Andhra. The population dependent on the agriculture for their livelihood. Maharashtra total population, that is agriculture labor, waiters together. The picture will indicate that Maharashtra in 1991 had less people dependent on agriculture, and in 2001 also the picture remains more or less the same. Next. Finally, they came to the allocation. Allocation done by KWT1, not disturbed. Done by this honorable tribunal. Parties to utilize strictly in accordance with the allocation given by this tribunal. Allocation has been made by this tribunal at different dependabilities. This tribunal has also directed constitution of implementation board for implementing their decision to oversee the use of water, and they also provided that after 31st May 2050, this tribunal can be reviewed and revised if necessary by the competent authority or by the tribunal. Next. The tribunal has given the mechanism to ensure proper utilization of at different dependability. So the first principle is that 30 states have to first utilize water allocated as per KWT 1. In the second instance, after the lower states have stored and are in a position to utilize their allocated share in first instance, the uppermost party state must store and utilize its share in 65% dependability. That means the implementation board has to be given all the data of current utilization, day-to-day basis, availability of the storage. All these data is to be shared with the implementation board as well as to the different state online sharing, and that will give indication that how much water has been already used, how much water store is available so that they can use that water. And therefore, if these together reaches the figure of allocation permitted by KWDT 1, then upper riparian state can start storing and utilizing water as per 65% dependability. The middle party, middle state, can utilize its 65% dependable flows only after ensuring that lowest party has achieved its utilization of 70, achieved the capacity to its 75% dependable flow allocated by the first level. In the third instance, when the lowermost state has 65% dependable flows, then uppermost state can store and start utilizing the water up to average dependable flows. Middle state can utilize when they have reached figures, lower state has reached the capability of utilizing 65%, and so on and so forth. The tribunal, there is a distinction between by KWDT 1 and KWDT 2. In earlier slides, I have shown you that the water which has been diverted for actual use is the use considered by KWDT 1. Whereas KWDT has clarified that the term utilized would mean the water utilized or diverted plus the amount of water stored in the state at any point of time in a year so as to be available in a storage for utilization to achieve its allocation in that water year. So this is a clear-cut distinction about utilization made by this Honorable Tribunal. The Tribunal has declared its award under Section 5.2 in December 2010 and final award in 2013 with clarification on points raised by the party states and central government. The Tribunal has decided that the distributed flows to be distributed at 65% dependability over and about 2130 TMC already distributed. Thus, the flows now to be distributed are 163 TMC at 65% dependability, and the surplus flows distributed are 285 TMC at average dependability. So, final allocation by KWDT 1 and KWDT 2 is given in this table. KWDT 1 gave Maharashtra 585, that is 560 plus 25, Karnataka 700 plus 34, and Andhra Pradesh 800 plus 11, total 2130. This total Maharashtra at 65%, 46 TMC, Karnataka 68 TMC, and Andhra Pradesh 49 TMC, total 163 TMC. Interesting decision of this tribunal is that from environmental and ecological angle, there are certain flows released by the riparian states, and they directed Maharashtra to release 3 TMC, Karnataka 7 TMC, and Andhra Pradesh 6 TMC. So thus 16 TMC flows will be flowing through the Krishna River for environmental and ecological purposes. from 65% dependable flows as well as average flows. The average flows allocated to the three states are 35, Karnataka 105, and Andhra Pradesh 145. So total allocation is 666 TMC to Maharashtra, 907 TMC to Karnataka, and 1005 TMC to Andhra Pradesh. AWTT too has directed to set up implementation board which shall monitor and water by the party states as per their allocated shares. For this purpose, all the party states are directed to establish mechanism to exchange online daily data with each other and also with the implementation board relating to opening and closing balances of all the reservoirs, the water which has been released in canals, and the 10 daily and monthly statement of their projects from the basin states. The data of measured flows at the sites maintained by CWC shall also be obtained by the parties on daily basis and shared to the implementation as well as to the party states. The implementation board shall have 5 members, chair 1 member from Government of India, 1 member each from the 3 party states, that is Maharashtra, Karnataka and Andhra Pradesh, competent to decide interstate complaints between basin states. All states mandated to send the storage data, use data on daily basis to implementation board. Upper states are not entitled to use allocation of at lower dependability unless the lower state allocation has realized allocation at next higher dependability. For the purpose of regulation, water stored in dams shall be considered as water use. Volumetric data of water storage and use to be exchanged between the states and supplied to implementation board on daily basis for all projects including minor projects. Some important clauses of the final order. The final order is a huge order, and those who are interested should go the actual report for all these orders, because limited time is available. I will be dealing with only important clauses from the final order. Clause 3, it is decided that the water of Krishna be distributed amongst the 3 states of Maharashtra, Karnataka and Andhra Pradesh on 65% dependability of the new series of 47 years, that is 2293 TMC. Clause 5, that it is hereby determined vital water at 65% dependability over and about 2130 TMC is 163 TMC. Clause 6, that it decided that the surplus flows which is determined as 285 TMC be also distributed amongst the 3 states. Clause 9, that since the allocations have been made at different dependability, the party states are directed to utilize the water strictly in accordance with the allocations, and for that purpose they are further directed to prepare or caused to be prepared 10 daily working tables and the rule curve, and shall furnish copies of the same to each other and on its coming into being also to the Krishna Water Decision Implementation Board. A. Alternatively, insofar it relates to the upper riparian states, that is Maharashtra, Karnataka, before storing their additional allocation of 46 TMC and 68 TMC respectively at 65% dependability, they have and or water flowed down the balance amount of share of Andhra Pradesh at 75% dependability at the relevant point of time, taking into account the self-generation of water due to rainfall in the state of Andhra Pradesh. Self-generation of water in Andhra Pradesh at 75% dependability may be taken as 369 TMC as per their own calculations made in the paper dated 16/4/2012. These were the argument notes delivered during the arguments at each part of the stage. B. Notwithstanding anything contained in subclauses 1 and A of clause 2 above, the three riparian states, in the light of the opinion of their experts about the assessment of expected rains or otherwise, in the best of their spirit of cooperation and share, and care to achieve their share fairly and smoothly, are free to make any other arrangement by means of a written agreement amongst the three states in respect of manner of withdrawal, as at what point of time they may draw their share in full or in parts thereof at 65% dependability. C. The agreement, if any, shall be jointly submitted to the board, and the board shall see to it that the drawal of water is made by the parties as per the agreement. If necessary, it may issue directions to the parties accordingly. The state of Andhra Pradesh shall not use over and above 811 TMC more than 49 TMC. In the third instance, not more than 280 TMC shall be used by the three states in the following manner. The state of Maharashtra shall not use over and above 30 TMC more than 35 TMC only after the state of Karnataka has used 802 TMC and the state of Andhra Pradesh has used 860 TMC. The state of Karnataka shall not use over and above 802 TMC more than 105 TMC only after the state of Andhra Pradesh has used 860 TMC. The state of Andhra Pradesh shall not use over and above 860 TMC more than 145 TMC. The above, allowing Andhra Pradesh to draw only its allocated shares at different dependability, does not affect the drawers used which Andhra Pradesh is entitled to as per provisions made in subpara of para 3 of clause 10 of the order, which allows Andhra Pradesh to use the remaining water. Notwithstanding the provision in clause 7 of the decision of KWTT 1, for the purpose of paragraphs 1 to 3 above only, the expression used would mean the water used or diverted plus the amount of water stored by any state at any point of time in a water year so as to be available in a storage for utilization of to achieve its allocation in that water year. Decision implementation board monitor and ensure the use of the water by the three states as allocated to them in the manner provided in the aforesaid paragraphs 1 to 3. Water which has flown down plus the water generation within the state at 75% dependability shall be deducted from the allocated share at 75% dependability, and the balance of amount of water shall be down with the due intimation along with the calculations to the lower riparian states at least 12 hours before the storing or using its allocation at 65% dependability. The gauging sites of CWC at interstate boundaries between Maharashtra and Karnataka and between Karnataka and Andhra Pradesh shall be used for measuring the flows of releases amongst the party states. 4. If the lower or lowest riparian state have any doubt about the correctness of the calculations made by the upper riparian states about the use, storage and the water which has been released or flowed down till that point of time to lower riparian states, in that event the states may ascertain the correct position from the implementation board, which shall check the same and provide it to them immediately within 12 hours. Information so far by the board shall be taken to be the correct position of water having released flowed down to the lowest riparian state. In the event the lowest riparian state informed to the upper riparian state that it is not in a position to receive the balanced flow of water of its allocation at 75% dependability at that point of time due to lack of storage capacity or the like. In that case, the parties enter into an agreement under clause 2b allowing storage of that part of the balance of allocation of the lowest riparian state also, which may be released later as and when so required by the lower or lowest riparian state or as agreed. In any water year, if it is known that the self-generation of water in the state of Andhra Pradesh is likely to fall short of 369 TMC and the state of Andhra Pradesh cannot realize its allocation of 811 TMC at 75% dependability and the upper riparian states have used the additional allocation, in that case, the state of Andhra Pradesh at the end of winter monsoon season shall intimate about the shortfall in 811 TMC with calculations of upper riparian which shall make good the shortfall if necessary on verifying the correctness of the claim. If defaults in timely exchange of data will not be entitled to question the calculation made by upper riparian state, which shall be treated as correct. Similarly, if an upper riparian state fails to furnish its data on time, will not be entitled to claim commencement of use of its additional allocation. The party states and the board shall make use of latest information technology and install a suitable real-time data acquisition system in the entire Krishna basin for the purposes of acquisition and exchange of reservoir and utilization data indicated in the following clauses. The same technology shall be used for data to be obtained from the gauging sites of Central Water Commission and the states, if any. The implementation board may get for this purpose the necessary software and hardware for quick and instant change of data, exchange of data amongst the states. The implementation board and the Central Water Commission, the board shall use all facilities in this regard available with the CWC and the party states. The board shall be responsible for installation and maintenance of the system. The financing of this activity of the board shall be covered by the clause 41 of the appendix 1 of the decision of the tribunal. Next. Very good slides. Clause 10. The restriction placed on the states on utilization in sub-basins. Maharashtra shall not utilize 98 TMC in a 65% dependable water year and 123 TMC in average water year from Bhima sub-basin. You must be knowing that for the restriction to use 95 TMC at 75% dependability, which has been now relaxed to 98 at 65 and 123 at average dependability for Maharashtra in Bhima sub-basin. Maharashtra shall not divert more than 92.5 TMC, including that allowed by KWTT 1 and further 25 TMC now allocated by this tribunal from K1 Upper Krishna sub-basin for hydel station for westward diversion in a 65% dependable or average water year. So the cap of 60 0.5 TMC diversion has been relaxed by this tribunal of 25 TMC for Koyna Hydro project. Maharashtra shall not use more than 620 TMC in a 65% dependable water and not more than 663 TMC in average water year. These figures are because TMC is to be released by Maharashtra for environmental flows. Maharashtra shall not divert water out of basin except B above from cable sub-basin. Karnataka shall not utilize more than 360 TMC from K8 Tungabhadra sub-basin in a 65% dependable water year. It includes allocation of 40 TMC for Upper Tunga, Upper Bhadra and Singatlur projects or in an average water year. Karnataka shall not utilize more than 190 TMC in a 65% dependable water year and not more than 303 TMC in an average water year from Upper Krishna project. It includes allocation of 133 TMC for UKP stage 3 with reservoir level of Almatti Dam at 524.256. Karnataka shall not utilize more than 799 TMC in 65% dependable water year and not more than 904 TMC in an average water year. This is because 7 TMC is to be released by Karnataka for environmental flows. 3. That the state of Andhra Pradesh shall not utilize more than 1001 TMC as per allocation made in clause 8 above in an average water year. It includes further allocation of 99 TMC for Jurala, 25 TMC for Telugu Ganga and 150 TMC for carryover storage in Shri Shailam and Nagarjun Sagar. Water is concerned, as may be available, that may also be utilized by the state of Andhra Pradesh, subject to any part of it being stored, trapped in future and or till the next review of the reconsideration by any competent body under the law. The above restrictions are inclusive of losses. Clause 11. That all the 3 states are hereby directed that for purposes of drinking water supply to Chennai city, which each state shall contribute 3.3 TMC in equal quantity distributed in the months of July, August, September and October, and 1.70 TMC distributed similarly in 4 equal installments in the months of January, February, March and April. Clause 12. That all the 3 states shall release in all 16 TMC of water for maintaining minimum stream flow, environment and ecology in the manner and the quantity as indicated in the table to the discussion held on the subject of minimum flows. Next. Clause 12. That it is hereby directed as provided in the discussion held while dealing with the issue number 14. That the state of Karnataka shall release 8 to 10 TMC of water to the state of Andhra Pradesh from Almatti reservoir in the months of June and July as regulated releases. Clause 14. That it is hereby provided that on the constitution of Krishna Water Decision Implementation Board, the administrative control and regulation over Tungabhadra Dam and its reservoir, including head regulators of all the canal system, both on the left and the right sides, and all its gates, as well as the administrative diversion scheme, shall vest in the board implementation board, and the notification dated 29 September 1953 and the 10th March 1955 issued under section 66(1) and 4 respectively of the Andhra State Act 1953 shall cease to be operative. Clause 15. Besides the gauging sites as indicated in clause 13 in the final order AWTT 1, the Krishna Water Decision Implementation Board may set up or cause to be set up more gauging sites as the board may consider necessary. No existing site nor any established hereinafter shall be abolished or downgraded except in consultation with the board. Next. At any time after 31st May 50, this order can be reviewed. Clause number 18, the scheme which is framed for implementation of this decision and the decision and directions made by KWDT 1, which have not been modified or reviewed by this tribunal, has been appended in Appendix 1 to this decision and forms part thereof. The board constituted to carry out the functions and duties provided for in the scheme shall be called Krishna Water Decision Implementation Board. It shall be constituted as early as possible. The central government and the state government shall nominate the members of the board at the earliest, in any case not later than 3 months from the date of publication of the decision. The board shall function as per the provision of the scheme. Clause 20. The provisions made in the decision order passed and the decision and directions given by KWDT 1, which have not been amended, modified or reviewed by this order, shall continue to be operative. Next. So these are the decision of this tribunal. It is interesting that the tribunal has also observed that there is a need for a broader outlook to view the entire problem. Allah states contesting the matter, realize it and put it into practice. These are the important observations of this honorable tribunal. But the unfortunate part is that though the tribunal has given its decision in 2013, the Andhra Pradesh Karnataka have filed the Supreme Court. In the year 2014, has been divided Telangana and Andhra Pradesh, and therefore there has been a dispute how to share the water of Krishna basin allocated to Andhra Pradesh and Telangana between the two states. Before the KWDT 2, the government has made reference to KWDT 2, directing KWDT 2 that whatever allocation has been made, that is the 1005 TMC, finally by KWDT 2, how to be distributed between two. This is the issue KWDT 2 has to decide. Meanwhile, when these SLPs were filed on 5.2 section on the award declared under 5.2 in 2010, the Supreme Court has permitted the tribunal to hear 5.3 and give clarification, but directed the central government that unless permitted by the Supreme Court, this decision shall not be notified. The decision of the Supreme Court in the matter is and therefore this decision of the tribunal has not been notified, and as such the decision of the tribunal, that is 75% dependable flows, is still continuing. Thank you for exhaustive clauses of this thing, but those who are interested can go through the final order of this tribunal, and those who want to pursue the career in tribunal matters really go through both the reports of this of the Krishna Water to understand how the things have been argued and how the decisions have been taken. Thank you.